Welcome back to the Deep Dive. This is where we grab a stack of sources, dive deep into the material, and pull out the absolute must-knows, the key insights, the surprising facts, the things that truly matter, giving you that essential shortcut to being genuinely well-informed without getting swamped by information overload. Today, we are embarking on a deep dive into a subject that is not only historically significant, but also incredibly relevant to millions of people worldwide right now: Islamic family law, with a laser focus on the rules and structure of marriage. Our source material for this deep dive comes from the University of London.
That's exactly right. Understanding Islamic family law is far from a purely academic exercise. It's the living law governing substantial Muslim communities across the globe, from Indonesia to Nigeria. And it frequently intersects with legal systems in countries like the UK, where courts might need to determine the validity of a marriage or divorce from places like India or Pakistan.
Yeah, absolutely.
These are legal principles with tangible, real-world implications for individuals and families.
And just so you're aware, this deep dive is based on material made available by the University of London for educational purposes only, and our discussion today is also intended strictly for educational use.
Indeed. And this exploration is brought to you by Sinorbit Academy, Sri Lanka. Our mission in this deep dive is really to serve as your guides, navigating the fundamental principles of Islamic marriage law as presented in this material, helping you build a robust understanding of the core concepts you need to grasp.
Okay, let's unpack this fascinating area. It's a legal system built over centuries with layers of rules and, as we'll see, some key differences between the traditional schools of thought. We're going to start with the very foundation. What actually is marriage legally?
hmm
Then we'll look at who has the capacity to enter into this agreement, delve into the historical context and evolution around child marriage and a related right, explore the different things that can act as barriers to a valid marriage, the impediments and what happens legally when those impediments exist. We'll cover how you prove a marriage took place, and finally, examine the unique and essential concept of dower, or mar. We're going to hit the key terms, concepts, and make sure the important case names stick with you because if you're studying this, they are absolutely critical.
Think of this as putting together a legal blueprint for Islamic marriage. We'll start with the bedrock, the contract itself.
So let's lay that first stone. What is marriage in Islamic law? The source material emphasizes a specific legal definition that might differ from purely religious or cultural understandings in other contexts.
Fundamentally, in Islamic law, marriage, nikah, is viewed primarily as a contract. While it holds immense religious and social significance, its legal validity is established through a contractual agreement between the parties.
Okay.
This isn't a sacrament in the same way some other religious traditions define it. It's essentially a civil contract with religious underpinnings.
And like any contract in law, it needs core elements to be valid. What are those here?
The essential legal components are offer and acceptance. One party, or maybe their representative, makes a formal offer to enter into the marriage contract, and the other party, or their representative, provides a clear acceptance of that offer.
Does this offer and acceptance need to be performed using specific, rigid legal phrases or Arabic terms? Does it require a formal, fixed script?
No, this is an important point from the source. No particular form of words is required, whether in Arabic or any other language, as long as the intention to conclude a contract of marriage is clear.
Right.
The focus is entirely on the substance, the unequivocal mutual intention and agreement to marry, expressed through the offer and its acceptance, rather than, strict adherence to ceremonial wording.
Okay, so intention is key, but how about timing and location? Does the offer and acceptance have to happen instantly, and do the parties need to be standing right in front of each other?
Well, the offer and acceptance must be of immediate effect. This means the acceptance must follow the offer without undue delay, concluding the agreement there and then. They must also take place within the context of the same meeting or assembly where the proposal is made and accepted. However, and this is perhaps counterintuitive from a modern Western perspective accustomed to physical presence for legal contracts, the source notes that the parties do not necessarily need to be in each other's physical presence.
Really?
Yeah. The contract can be validly concluded through appointed representatives, wakils, acting on their behalf, as long as the offer and acceptance occur within that single defined meeting or session where the representatives convene.
That's interesting. Representatives can stand in for the parties. Now, while the bride and groom might not need to be face-to-face, there is another requirement involving other people that's absolutely critical for validity in most schools: witnesses.
Ah, yes.
And this is where the different traditional schools of Islamic law show some key divergence.
Yes, the requirement for witnesses is a vital formal element, and the difference between the major Sunni schools and the Ithna Ashari Shia school is a point you absolutely need to remember. According to the dominant opinion in the Hanbali, Hanafi, and Shafi'i schools, the presence of two adult males is an indispensable condition for the validity of the marriage contract. These witnesses must be present and hear the offer and acceptance being exchanged.
Right, they have to hear it.
Exactly. Without their valid testimony, the marriage is not considered legally concluded in these schools.
Okay.
In contrast, the Maliki and Ithna Ashari schools have a different perspective. For them, while the presence of witnesses is highly recommended for ensuring publicity and avoiding disputes, it is not considered an essential condition for the validity of the marriage contract itself.
So recommended, but not essential.
Precisely. The Maliki school specifically states that if witnesses are not present at the moment of contracting, there must be sufficient publicity given to the marriage thereafter.
Ah, okay. Publicity.
Yes, this publicity ensures that the union is known within the community, which serves a similar purpose to witness testimony and preventing, secret marriages that could lead to uncertainty or harm.
So, to make sure this foundational section is crystal clear for everyone listening, Islamic marriage is first and foremost a contract. It's built on offer and acceptance, where the intention is paramount, not rigid words.
Right.
The agreement must be of immediate effect and happen within the same meeting, though physical presence isn't strictly necessary if representatives are used. And crucially, the requirement for witnesses, specifically two adult males in the Hanbali, Hanafi, and Shafi'i schools, versus publicity being key in others like Maliki, is a major point of difference you need to understand.
Exactly. That contractual bedrock is the starting point for everything else that defines an Islamic marriage.
All right, we've established the structure of the contract, offer, acceptance, witnesses, but not everyone can just walk in and enter this contract. That brings us to the question of capacity. Who is legally able to get married under Islamic law? The source highlights that the primary factor here, especially in traditional law, is age.
Traditionally, yes. The concept of legal capacity for marriage, which is often linked to the attainment of majority, was based on the onset of physical puberty. This biological event was the traditional legal benchmark.
And the traditional legal system even created some strong, definite rules around age and puberty, almost like hard cutoffs.
Exactly. The source describes these as irrebuttable presumptions of law. This means that legally, these presumptions cannot be challenged or disproven, regardless of biological reality.
Okay.
There is an irrebuttable presumption that no female below the age of 9 and no male below the age of 12 has attained majority. So, if a girl is 8 or younger, or a boy is 11 or younger, they are legally considered minors without the capacity to marry, irrespective of early biological development.
Right.
Conversely, there is an equally strong, irrebuttable presumption that by the age of 15, majority has been attained by both sexes.
Yeah.
So once a person reaches 15, they are legally considered an adult with capacity for marriage purposes in the traditional framework, even if physical signs of puberty haven't fully manifested.
Got it.
These age markers are very specific and important in the traditional legal calculations.
Now, capacity becomes much more intricate and often a point of modern debate when we consider the role of a woman's capacity and whether she needs a guardian, known as a wali, to conclude her marriage contract. This is where we see significant divergence and historical complexity.
Absolutely. The role of the wali is a central and often contested aspect of women's legal capacity in Islamic marriage.
Right.
According to the Hanafi and Ithna Ashari schools, any sane adult, whether male or female, possesses the capacity to conclude their own contract of marriage. This grants adult women the legal right to act as the contracting party in their own marriage agreement.
Okay, so they can do it themselves in those schools.
Yes. However, the Maliki, Shafi, and Hanbali schools hold a different, more restrictive view. Their position is that a woman may never conclude her own marriage contract. A marriage guardian, wali, must always act on her behalf, conducting the offer and acceptance on her behalf.
Always needs a guardian in those schools. Okay, even within the Hanafi school, where an adult woman can contract herself, her right wasn't traditionally seen as completely unfettered, was it? The source mentions certain doctrines that gave guardians influence.
That's correct. Traditional Hanafi doctrine incorporates limitations that provide guardians with grounds to object or intervene, even if the woman contracts herself.
Like what?
One check relates to dower, more, which we'll discuss in detail later. If a woman contracts her own marriage for less than the proper dower, the amount considered appropriate for a woman of her status, her guardian can step in.
Right.
He may demand that the proper dower be paid, or he can even seek the dissolution of the marriage.
Wow, okay.
Another doctrine is equality, kafa. A guardian can seek dissolution if the woman marries a man who is not considered her equal according to certain traditional criteria in Hanafi law, which include things like piety, lineage, wealth, and occupation. The aim was often to maintain social standing.
Equality. Got it.
Here's a crucial detail, though. The guardian's right to demand dissolution based on inadequate dower or lack of kafa lapses, and is extinguished if the woman becomes pregnant.
Ah, pregnancy changes things.
Yes. The pregnancy legally solidifies the union against these specific guardian objections.
So even in the schools where the adult woman can contract herself, the traditional guardian's influence is still felt through these potential objections. And the source points out that despite the legal right in some schools, the usual practice might be different.
Yes, even in Hanafi and Ithna Ashari schools, the source notes that it is the usual practice for the woman's guardian, typically her father, or the nearest male relative in the order of succession, to conclude the contract on her behalf.
Okay.
However, when the guardian acts in this way, he is legally considered to be acting as the woman's representative, and therefore her consent is nevertheless required for the marriage to be valid.
Right. Her consent is still key.
Absolutely. She hasn't given up her right to consent. The guardian is simply performing the legal act on her behalf.
This brings up the question of how a woman's consent is obtained or understood, particularly for a virgin, given historical cultural norms.
Right. The traditional Hanafi view, as presented in the source, distinguishes between a previously married woman and a virgin. If she is not a virgin, her consent must be express. She must clearly and unambiguously state her agreement.
Okay, express consent.
If she is a virgin, her acceptance may be implied by conduct.
Implied. How does that work?
Well, the interpretation of this implied consent for virgins in traditional Hanafi law is quite fascinating, and sometimes controversial from a modern viewpoint. Remaining silent when asked if she consents to the marriage is traditionally interpreted as shyness, and silence due to shyness is legally regarded as consent.
Silence means yes.
In that specific context, yes, traditionally. Some jurists even held that weeping could be interpreted as consent, seeing it not as a rejection, but as sadness at the prospect of leaving your family home and parents.
That's quite an interpretation.
It highlights the nuances and specific reasoning within traditional legal interpretations regarding a virgin's consent, certainly.
Let's return to the Maliki, Shafi, and Hanbali schools, where a guardian must contract the marriage. Who is the designated guardian, and is there a pecking order?
Yes, in these schools there is a well-defined hierarchy of marriage guardians. This hierarchy often follows the order of succession that determines inheritance rights among male relatives.
Okay.
For example, in Maliki law, the hierarchy is quite strict, and perhaps surprisingly to some, a woman's son ranks before her father as her marriage guardian.
Her son before her father?
Yes. If there are no sons, the father, then the paternal grandfather, and then other nearest male relatives would follow in order of priority. In Hanbali law, the father typically has the first priority as guardian, followed by the paternal grandfather, and then other male relatives in a specific order.
Right.
Both schools acknowledge that a guardian can legally delegate his authority by appointing someone else to act as his representative.
And it's within these schools, specifically when the father or paternal grandfather is the guardian, that a deeply traditional and historically powerful right existed known as ijbar. This sounds like it carries significant weight.
It certainly does. Ijbar is the right to compel marriage. According to the traditional law in the Maliki, Shafi, and Hanbali schools, if the woman's guardian was her father or her paternal grandfather, he possessed the right to contract her hand in marriage without her consent and even against her express wishes.
Without consent, even against her wishes.
Yes. This right could be exercised even if the woman was an adult, provided she had never been married before. So traditionally, a father or paternal grandfather held the legal power to force an adult, never married daughter or granddaughter into a marriage against her will under the principle of ijbar.
Wow.
To emphasize this crucial point for you. Ijbar is the traditional right of the father or paternal grandfather to compel the marriage of an adult, never married woman, even if she explicitly refuses, in Maliki, Shafi, and Hanbali law.
That rule about compelling marriage against someone's express wishes is certainly jarring from a modern perspective. The source indicates that this particular right has been significantly reformed in contemporary legal systems.
Yes. Thankfully, the right of ijbar has been removed by modern legislation in the vast majority of Muslim-majority countries. The source mentions that Morocco was the last Muslim country to retain this specific right in its statutory family code, but it was eventually removed in their significant family law reforms of the 2004 Mudawana.
Okay, so reform has happened widely.
Widely, yes. However, it is a critical point for your understanding that the right of ijbar may continue to exist in countries which have not yet implemented statutory reform to explicitly abolish this traditional principle. This highlights the diversity and ongoing evolution of legal systems across the Muslim world.
Right, it's not uniform everywhere. Speaking of modern legal contexts and the right of an adult woman to choose her spouse, there's a highly important case from Pakistan that directly confronted the issue of an adult Hanafi woman marrying without her father's consent. This is a case that's essential to know if you're studying this area.
Absolutely. This is a landmark decision that illustrates how traditional principles are interpreted and applied in modern courts.
Oh.
The case is Abdul Wahid v. Asma Jahangir, PLD 1997 Lahore 301, which is universally known as the Sama Wahid case.
Okay, Sama Wahid case. Got it.
The facts of the case involved an adult woman who followed the Hanafi school of thought. She entered into her own marriage contract without obtaining the consent of her father, who was traditionally her guardian. Her father then challenged the validity of the marriage in court, arguing that his consent was necessary.
Right.
The Lahore High Court was tasked with deciding whether an adult Hanafi woman could validly contract her own marriage without her guardian's permission. The source notes that the court very reluctantly rejected the father's application.
Reluctantly.
Well, the court's decision, despite its stated reluctance, was primarily based on the fact that it felt legally bound by a precedent that had been set by a higher court, the Federal Shariat Court of Pakistan.
Ah, bound by precedent.
Exactly. That precedent had previously ruled that according to Islamic law as interpreted and applied in Pakistan, an adult Muslim woman did not need the consent of her marriage guardian to enter into a valid marriage contract.
So this Sama Wahid case is a prime example of the tension between traditional legal doctrines and their application in contemporary legal systems. It demonstrates how judicial precedent can affirm and solidify an adult woman's right to marry without her guardian's consent, at least within the context of Hanafi law as applied in Pakistan.
Precisely.
So remember that case name, everyone. Sama Wahid case, Abdul Wahid v. Asma Jahangir. It's a key legal development illustrating the evolution of capacity rules. Continuing our discussion on capacity and age, let's specifically address the issue of child marriage. The source highlights that, traditionally, Islamic law didn't set a rigid minimum age for marriage.
That's correct. In the traditional Islamic legal framework, there was no specific minimum age explicitly laid down for marriage. The source explains that certain guardians were traditionally permitted to contract their infant ward's children who had not yet reached puberty into marriage, potentially even without their consent at that stage.
Marrying off an infant sounds deeply concerning from a modern perspective. Was there any traditional mechanism to protect the child or allow them a choice once they reached maturity?
Yes, within the Hanafi school of law, there was a significant traditional safeguard specifically for girls married in infancy. This was known as the option of puberty, Khiyar al-Bulugh.
Okay, the option of puberty, what is that?
The concept is this. A girl who was contracted into marriage by her guardian during her infancy, before reaching puberty, may, upon attaining puberty, choose to repudiate the marriage.
Ah, so she gets a choice later.
Exactly. It gave her a critical legal avenue to annul a marriage she did not enter into by her own will as a child. Repeat that for everyone. The option of puberty is a right allowing a girl married as an infant to repudiate that marriage when she reaches puberty.
How long does she have to exercise this option when she reaches puberty?
She retains this right until she becomes aware of the existence of the marriage that was contracted for her, subsequently assents to it.
Assents. How?
Assent can be demonstrated through her conduct after reaching puberty, such as by permitting the marriage to be consummated. So she becomes aware of the marriage after puberty and through her actions indicates acceptance. She loses the option to repudiate it.
Does this important option of puberty apply universally to any child marriage contracted by a guardian?
No, this is a critical limitation you must be aware of. The source explicitly states the woman does not possess this option of puberty if the guardian who contracted her marriage when she was an infant was her father or her paternal grandfather.
Ah, okay. So if the father or grandfather arranged it, no option.
Correct. This is a very significant exception. If her closest male ascended guardians arranged the marriage during her infancy, she traditionally forfeited this specific right to repudiate it later upon reaching puberty. Repeat, no option of puberty if the infant marriage was contracted by the father or paternal grandfather.
The source also mentions that while the option of puberty is available to both males and females, it's most significant in practice for females. Expert speaker. Yes, because a male, once he reaches puberty, already gains the power of talaq, the husband's right to pronounce divorce unilaterally, which is a whole other topic.
Exactly, a whole other deep dive. Since males already have this broad power to terminate a marriage, the option of puberty provides a specific and crucial mechanism for females married as infants to escape a union they didn't choose once they attain legal majority through puberty.
If a girl decides to exercise her option of puberty and repudiate the marriage, is the marriage automatically dissolved immediately?
No, according to traditional Islamic law, as presented in the source, it's not an automatic dissolution. When a girl exercises the option to repudiate a marriage contracted by her guardian during infancy, she must approach the qadi, the judge, in an Islamic court.
Okay, she needs to go to court.
Yes. The marriage is legally deemed to subsist, meaning it continues to exist legally until the qadi issues a formal decree dissolving it based on the proper exercise of the option of puberty. So, judicial confirmation is a necessary step in the traditional process. Repeat, exercising the option of puberty requires a formal decree from the qadi to dissolve the marriage.
How have modern legal systems in Muslim-majority countries addressed the issue of child marriage?
Modern legislation across many countries has sought to directly combat child marriage by establishing minimum ages for marriage. The source gives examples like the Child Marriage Restraint Act 1929, which applied and its principles continue in modified forms in the Indian subcontinent, Pakistan, India, Bangladesh, and various personal status codes implemented in the Arab world. These laws set specific age thresholds below which marriage is generally prohibited.
And does setting a minimum age in modern law automatically make any marriage below that age null and void?
This is a very important distinction to make. The source notes that under some, though not all, of these modern legislative frameworks, the marriage itself is not necessarily rendered invalid solely because one or both parties were below the statutory minimum age.
Okay, so it's not always invalid.
Not always. Instead, the focus of these laws penal sanctions, fines, or imprisonment on the adults who participated in or facilitated the marriage, such as the parents, guardians, the officiating clergy, or the witnesses.
So punish the adults involved.
Exactly. This reflects a legal strategy focused on punishing the act of arranging or conducting a child marriage, rather than automatically nullifying the union itself, although the precise effect on validity can vary significantly depending on the specific country's legislation. Repeat that. Modern laws establish minimum ages and often impose penalties on adults involved, but the marriage's validity may vary by specific statute.
So, traditional law allowed infant marriage, but offered a complex mechanism for repudiation, the option of puberty, with exceptions and requiring judicial dissolution, while modern law aims to prevent child marriage outright by setting age limits, often punishing those responsible rather than always invalidating the marriage itself. Two very different approaches to the same underlying issue.
Precisely.
Moving on from capacity, let's explore the list of circumstances or relationships that legally prevent a valid marriage from being contracted in the first place. These are known as impediments.
Impediments are explicit prohibitions on marriage based on specific verses in the Quran and narrations from the Sunnah of the Prophet Muhammad, peace be upon him. The source helpfully categorizes these impediments into two main types: permanent impediments and temporary impediments.
Let's break down the permanent impediments first, the absolute bars to marriage that can never be removed.
There are three primary sources of permanent impediments mentioned in the source. One, relationship by blood, consanguinity. You are prohibited from marrying certain individuals based on your direct blood ties. This includes your ascendants, your mother, grandmothers, etc., up the chain, and your descendants, your daughter, granddaughters, down the chain.
Okay, parents, children, grandparents, grandchildren.
Exactly. It also includes descendants of your father or mother. So your sisters, full, half, or step, your paternal aunts, and your maternal aunts, and the immediate child of any ascendant, meaning your nieces and nephews. The same prohibitions apply reciprocally, of course.
Got it. Blood relatives.
To city, fosterage, relationship through milk. This is a significant and sometimes surprising impediment to those unfamiliar with Islamic law. A relationship established through nursing or suckling by a woman other than one's biological mother creates a bond that is legally considered as strong a bar to marriage as blood relation.
Really? Same as blood.
Yes. The key rule here is that two persons who are suckled by the same foster mother are permanently barred from marrying each other. This means that if you shared a wet nurse with someone else, Islamic law considers you foster siblings, and marriage between you is permanently prohibited. Repeat. Fosterage through suckling creates a permanent marriage impediment equivalent to blood relationship.
Okay, fosterage. That's important. Number 3.
3. Affinity. This impediment arises from marriage. It creates prohibitions based on relationships formed through a valid marriage. A man cannot marry the former wife of any of his ascendants or descendants. So, for example, he can't marry his father's ex-wife or his son's ex-wife.
Right.
He also cannot marry any ascendant or descendant of a former wife with whom he had consummated his marriage. This means he cannot marry his former wife's mother, his mother-in-law, or her daughter, his stepdaughter, but only if he had marital relations with the former wife.
Ah, the consummation part is key there.
It is. Note that consummation is a specific condition here for the latter part of this affinity rule.
Those are the permanent bars rooted in blood, milk, and marriage. What about the temporary impediments? These are circumstances that prevent marriage at a specific point in time, but which could potentially be removed, making marriage permissible later.
Right. There's a longer list of significant temporary impediments. 1. A man cannot marry a woman who is already legally married to another man. Islamic law permits polygyny men marrying multiple wives, but not polyandry women marrying multiple husbands.
Okay, can't marry someone already married. Makes sense.
He cannot marry a woman who is still observing the Ida period following the termination of a previous marriage. The Ida is a mandatory waiting period, typically 3 menstrual cycles or a fixed duration, like 4 months and 10 days for a widow.
The waiting period,
Yeah,
Ida.
exactly. She must observe this Ida after divorce or the death of her husband before she is legally permitted to remarry. It serves several purposes, including confirming paternity if she's pregnant and providing a sort of cooling-off period.
Okay, what else?
3. A very specific temporary impediment applies if a man has divorced a woman using the triple repudiation, pronouncing talaq 3 times, or in a manner interpreted as final divorce. He is prohibited from remarrying that same woman unless she has, in the period following that triple divorce, contracted a valid marriage with another man. That second marriage has been genuinely consummated and subsequently terminated, either by death or divorce, and she has then observed her Ida period from that second marriage.
Wow, that's complex. An intervening marriage is required.
Yes, this intervening marriage and its termination is a mandatory and complex step, sometimes called halala, before remarriage to the first husband is legally possible after a triple repudiation.
Okay, number 4.
4. A man cannot simultaneously be married to 2 women who, if one were a male, would be prohibited from marrying each other. The source clarifies the primary examples. He cannot be married at the same time to 2 sisters, nor can he be married simultaneously to a mother and her daughter.
Right, can't marry 2 sisters at once or a mother and daughter. Repeat that. Cannot be married simultaneously to 2 sisters or a mother and her daughter.
Exactly. It prevents certain close relationships from being combined within one marriage.
Got it. Next.
5. Related to multiple wives, a man who already has 4 wives cannot validly contract marriage with a 5th wife. The maximum number of wives permitted simultaneously under traditional Islamic law is 4. Repeat. Maximum of 4 wives simultaneously.
Okay, 4-wife limit.
6. There's also a significant impediment related to religion, but it applies differently based on gender, which is a key point. A Muslim man may validly contract marriage with a non-Muslim woman, provided that woman is a kitabiyah.
Kitabiyah. What does that mean?
Kitabiyah refers to people of the book, which the source specifies as Christians and Jews. So a Muslim man can marry a Christian or Jewish woman.
Okay. But what about Muslim women?
This is the crucial difference. A Muslim woman may only validly contract marriage with a Muslim man. She is prohibited from marrying a non-Muslim man. This is a strict, religiously based impediment that creates a significant difference in marriage permissions based on the individual's gender.
Right, that's a major distinction. The source also briefly mentions a few other, less universally applicable, temporary impediments.
Yes, specific instances listed include, for the non-Hanafi schools of Sunni Islam, a marriage that was concluded by the woman herself without her guardian's consent would be considered invalid, tying back to our capacity discussion.
Right, where the wali is mandatory.
Exactly. Also, a marriage concluded by a person who is currently performing the Hajj, though a major pilgrimage to Mecca, is considered prohibited during that specific state. And specifically within Maliki law, the marriage of a person who is in a state of death sickness, a terminal illness expected to lead to death, is prohibited.
Okay, so if a marriage ceremony takes place despite the existence of one of these impediments, what is the legal status of that union? Does it simply mean the marriage never happened? The source makes a very important distinction here that has significant legal consequences.
That's right. The presence of an impediment means the marriage is legally flawed, but the outcome isn't always total nullity. The impediment renders the marriage either void, the Hanafi term is batil, or irregular. The Hanafi term is fasid.
Void batil or irregular facet.
Okay. Understanding this distinction is absolutely crucial because the legal effects are very different.
Which type of impediment leads to a void marriage and which leads to an irregular one?
Generally speaking, the impediments that have the potential to render a marriage void, meaning it's legally non-existent from the outset, as if it never happened and has no legal effects whatsoever, are the permanent ones. So those based on relationship by blood, fosterage through milk, or affinity.
The permanent ones usually mean void.
Usually, yes. It also includes certain temporary impediments that the parties cannot themselves remove or rectify, such as one of the parties being already married to someone else when the marriage is contracted. If the impediment is permanent or fundamentally impossible for the parties to overcome immediately, the marriage is likely void or batil.
Okay. So what makes a marriage irregular or facet?
Well, where any other impediment exists, which typically means the temporary impediments that the parties could, in principle, remove or rectify.
Like completing the Ida period.
Exactly. Or the man divorcing one of his 4 wives to marry a 5th, or the non-Muslim partner converting to Islam if required. In these cases, the marriage is not considered void, but irregular or facet. This signifies that the marriage is legally flawed and should be terminated, but it possesses some degree of legal validity or semblance that produces certain legal effects, unlike a void marriage which has none.
Got it. Repeat that distinction. Permanent or unremovable temporary impediments generally lead to a void batil marriage. Other temporary impediments usually result in an irregular facet marriage.
That's the general rule, yes.
So an irregular marriage isn't treated as completely invalid. What are the specific legal consequences or effects of an irregular marriage? This is where the semblance principle becomes very practical.
Yes. The effects of an irregular marriage are significant and provide legal protection that wouldn't exist in mere cohabitation outside of marriage, despite being irregular. 1. The parties will not be found guilty of zina, illicit sexual relations, for engaging in sexual relations within this union.
Okay, no zina. That's huge.
It is. The legal semblance is sufficient to prevent this severe religious and legal charge. Repeat. No charge of zina for parties in an irregular marriage.
What about children?
Crucially, any children born to the parties during the subsistence of this irregular union will be held to be legitimate. This is a major protective effect, ensuring the legal status and rights of the children are not compromised by the flaw in their parents' marriage contract. Repeat. Children born from an irregular marriage are legitimate.
Okay, legitimate children. But the marriage itself can't continue.
3. No. Because the underlying impediment makes the marriage flawed, the parties must separate once they become aware of the impediment. The irregular union cannot legally continue.
Right.
4. When the parties separate from an irregular marriage, regardless of whether it was consummated, the woman must observe an Ida period, similar to the waiting period required after a valid divorce.
Okay, Ida applies.
5. The irregular union raises the bar of affinity in respect of any other potential marriage. This means that the prohibitions on marriage, due to affinity, will apply based on the relationships established through this irregular union, just as they would for a valid marriage.
Right. And dower.
Finally, the woman is entitled to dower, but only if consummation of the marriage has taken place. If there was consummation, the amount of dower she is entitled to is specifically the dower amount that was stipulated in the contract, or the proper dower, whichever is LSS.
This is a distinct rule for dower entitlement in irregular marriages that have been consummated. Okay. Dower only if consummated, and it's the lesser amount. That distinction between void and irregular, and especially the legal effects of an irregular marriage, is a really nuanced but important point. And the source highlights an absolutely remarkable principle where a marriage that could be void might be treated as irregular if the parties acted in good faith. This sounds quite unique in law.
It is indeed quite striking and provides a measure of leniency. The source explains that a marriage which might otherwise be held to be potentially void due to a permanent or unremovable temporary impediment will be regarded as irregular if the parties have acted in good faith concerning the impediment.
Oh, big faith. What does that mean here?
Now, good faith, in this very specific context, has a precise meaning. It means the parties were either genuinely unaware of the existence of the impediment when they contracted the marriage, or they knew the impediment existed but did not realize its legal effect, meaning they didn't understand that this specific impediment legally prevented a valid marriage.
Yeah, so they didn't know or didn't understand the rule.
Exactly. This is highly significant because, as the source explicitly points out, this is the only case in Islamic law where the general legal principle that ignorance of the law is no excuse, ignorantia juris non excusat, is not applied.
Really? The only case?
Yes, it is the only instance where Islamic law recognizes ignorance of the law as a defense, specifically limited to the context of potentially void marriages entered into in good faith regarding the impediment's existence or its legal consequence. Repeat that for everyone. Ignorance of the law is a defense only in this specific case of potentially void marriages entered into in good faith concerning the impediment.
Just quickly on terminology, the different schools use slightly different terms for these concepts, don't they?
Yes, as we mentioned, the Hanafi school uses the specific terms batil for a void marriage and fasid for an irregular marriage. Other Sunni schools sometimes use these terms less precisely or interchangeably, but they generally describe an irregular marriage as one that has a semblance to a valid marriage, acknowledging its partial legal validity and the resulting effects we've discussed.
All right, let's say you've gone through the process. The contract is concluded, and you believe you have a valid Islamic marriage according to these rules. How do you legally prove that the marriage took place? This is essential for asserting rights and obligations in legal settings.
Right. The source outlines both the traditional methods of proof of marriage that were developed over centuries and the ways this is handled in modern legal systems.
Okay, what are the traditional ways?
In traditional Islamic law, the primary method of proving a marriage was through direct evidence. This required the testimony of two witnesses who were present at the conclusion of the marriage contract and could testify to that fact before a Sharia court.
The witnesses again?
Yes. And the requirements for these traditional witnesses were quite specific and demanding. They had to be adult, sane, male Muslims who possessed the quality of adala.
Adala, what's that?
Adala is a crucial concept here. It means they must be deemed to be of the highest moral probity and upright character, considered trustworthy enough for their testimony to be accepted in a court of law. Repeat. Traditional proof requires testimony of two adult, sane, male Muslim witnesses with adala, high moral probity.
Okay. What if you didn't have those witnesses?
Well, if direct evidence was unavailable or insufficient, traditional Islamic law also allowed for marriage to be proved by indirect evidence. This involves presenting circumstantial proof to convince the court that a marriage exists or existed.
Like what kind of proof?
Examples given include demonstrating that the parties have lived together publicly and for a long period as husband and wife, and that they are accepted as husband and wife by their family and acquaintances within the community. Their reputation as a married couple could serve as proof.
Okay, reputation and living together. How have modern legal systems in Muslim-majority countries integrated civil registration into this? Does having a marriage certificate replace traditional proof methods?
Well, at the present time, many countries with significant Muslim populations have enacted legislation requiring the registration of marriage with a civil authority. The source lists Pakistan, Egypt, Tunisia, Kuwait, and Jordan as examples of countries with such laws.
Right.
In these jurisdictions, the best and most straightforward proof of marriage is undoubtedly the production of a marriage certificate that was issued upon the official registration of the union.
Makes sense. The certificate is the best proof.
It is. However, and this is a very important practical point from the source, failure to register a marriage will not, in most of these jurisdictions, automatically invalidate the marriage itself.
Ah, okay. So not registering doesn't always mean it's invalid.
Correct. While registration is a legal requirement, and failing to do so might incur penalties for the parties or officials involved, the marriage can generally still be proved using the traditional methods we just discussed, through the testimony of witnesses who are present, or through compelling indirect evidence of cohabitation and public reputation as spouses. Repeat that. Failure to register a marriage usually does not invalidate the marriage itself. Traditional proofs can still be used in court.
Good to know.
Furthermore, modern courts are increasingly willing to accept contemporary forms of evidence. The source mentions that video and DVD evidence showing the marriage ceremony taking place can now be accepted by courts as proof that a marriage contract was concluded.
Okay, so video proof is accepted too. So while registration and the resulting certificate are the gold standard for proof in modern systems, the traditional methods of proving the contract through credible witnesses or established public reputation remain relevant, especially in cases where registration didn't occur or records are missing. Let's turn now to what the source describes as a feature that is, in many ways, unique to Muslim marriage: the requirement of dower, universally known by its Arabic term, mar.
More. Yes. It's a fundamental and mandatory financial obligation that the husband owes to his wife upon marriage. The husband must give dower to the wife. It is her exclusive legal right arising directly from the marriage contract, and it becomes her personal property. Repeat.
Hmm.
Mar is a mandatory payment from the husband to the wife.
Do the parties have to agree on a specific amount for the dower and write it explicitly into the marriage contract for it to be due? What happens if they don't mention it or even agree there won't be any more?
This is a core characteristic of Mar that differentiates it from concepts like a gift. While the parties may stipulate a specific amount of dower to be paid in the marriage contract, this is called the stipulated or specified dower, Mar Misama, the obligation to provide dower exists regardless. Yes. Even if no dower amount is stipulated in the contract at all, or even if the contract expressly states that no dower shall be payable and the wife seems to agree to waive it, the wife is nevertheless legally entitled to receive dower.
Wow. So it's automatic.
It's considered an inherent right of the wife upon marriage, mandatory by law, and cannot be legally contracted away. Repeat.
Hmm.
Mar is always legally due to the wife, even if it is not mentioned in the contract or if the contract attempts to exclude it.
Okay, so if no amount is stipulated, how is the dower amount determined? Is it just an arbitrary sum?
Not at all. In that situation where no specific dower was fixed in the contract, the wife is legally entitled to what is termed the dower of equivalence, or more commonly, the proper dower, mar mithl.
Proper dower. Okay.
Right.
How's that calculated?
The proper dower is not an arbitrary figure. It's calculated based on established legal criteria, aiming for fairness according to social standing. It's determined by taking into account the amount of dower that has been received by comparable members of the wife's own family, such as her sisters or her paternal cousins, who are considered to have similar status and attributes to her.
Right, based on her family.
Yes, and her personal attributes are also factored into this calculation, including her historical status of virginity, her age, her level of education, her beauty, her social standing, and her wealth, if any. Repeat. Proper dower, mar mithl, is calculated based on dower received by family comparables and the wife's personal attributes.
When is this dower, whether stipulated or proper, actually paid to the wife? Does it have to be all at once?
The parties have the flexibility to agree on the timing of the dower payment, and it can be divided into two parts. They can agree that the entire dower is paid at the conclusion of the contract or at some later stage. More commonly, it is divided
Okay.
into prompt dower, mar muajjal. This is the portion of the dower that is agreed to be paid upon the conclusion of the contract or immediately upon demand by the wife.
Prompt dower, paid up front.
And deferred dower, mar
Yeah.
muajjal. This is the portion of the dower that is agreed to be postponed and will become due at a later event, specifically upon the termination of the marriage, whether by the death of the husband or by divorce.
Deferred dower, paid later. Repeat that. Dower can be split into prompt, paid at contract and demand, and deferred, paid upon marriage termination.
Exactly.
Does the wife have any legal right or leverage to ensure she actually receives the prompt dower portion?
Yes, she does. The source states that the wife has a significant legal right concerning the prompt dower. She may refuse to allow the consummation of the marriage until the husband pays her the first portion of the dower, meaning the prompt dower that was agreed to be paid immediately or on demand.
Ah, she can refuse consummation.
Yes, this provides her with legal leverage to compel the husband to fulfill this initial financial obligation before marital relations commence.
When does the wife become legally entitled to receive the entire dower amount, including the deferred portion?
She becomes entitled to the whole of the dower, both prompt and deferred, in two main circumstances. One, once consummation of the marriage takes place. The act of marital intimacy makes the full dower, including any deferred portion, immediately due to her.
Okay, consummation means full dower.
Two, or by the death of the husband, even if the marriage has not been consummated before his death. In this scenario, the deferred dower becomes an outstanding debt on his estate, payable to the wife or her heirs.
Right, death also means full dower. What happens to the dower entitlement if the marriage is terminated before it has been consummated, specifically through divorce?
This is a distinct rule. If the marriage is ended by divorce before any consummation has taken place, the wife's entitlement to dower changes. If a specific dower amount was fixed in the contract stipulated dower, and the marriage is divorced before consummation, she is entitled to receive half of that stipulated dower amount. Repeat. If divorced before consummation and dower was stipulated, she gets half of the stipulated dower.
Half. Okay. What if no dower was fixed?
If no dower amount had been fixed in the contract, so she would have been entitled to proper dower if the marriage was consummated and the marriage is divorced before consummation, she is not entitled to the proper dower. Instead, she is entitled to a muta al-talaq.
Muta al-talaq, what's that?
This is described as a gift of consolation from the husband given to ease her departure. Repeat.
Yeah.
If divorced before consummation and no dower was fixed, she receives a muta al-talaq, gift of consolation.
A consolation gift.
Okay.
This requirement for mahr seems like a powerful financial protection for the wife. Was this always a feature in the Arabian context?
No, and the source highlights this as a significant historical reform. The requirement of dower, mahr, being paid to the wife herself was one of the most significant social and legal reforms affected by the Quran.
How so?
In the pre-Islamic Arabian period, it was common practice for a financial payment, often referred to as a bride price, to be made by the groom or his family, but typically this payment went to the bride's father or guardian, not to the bride herself.
Ah, it went to the father before Islam.
Generally, yes.
Yeah.
The Quranic injunction to give women their dower explicitly directed this payment to the wife, making it her personal property and a symbol of her worth and financial security within the marriage, fundamentally changing the dynamic from a payment to the father to a right of the wife.
Right.
This illustrates the transformative purpose behind the rule.
So to recap these key points about mahr, which are absolutely vital to remember for anyone listening, especially if you're studying, it's a mandatory financial right for the wife, always due, even if not mentioned in the contract. If not stipulated, the proper dower is calculated based on dower of family comparables and the wife's personal attributes. It can be divided into prompt, due at contract and demand, and deferred, due upon marriage termination. The wife has the legal leverage to refuse consummation until the prompt dower is paid. She becomes entitled to the full dower upon consummation or upon the husband's death before consummation. And if the marriage is terminated by divorce before consummation, she receives half of the stipulated dower if an amount was fixed, or a muta al-talaq, gift of consolation, if no dower was fixed. This mandatory right is a cornerstone of the Islamic marriage structure and represents a historical shift towards empowering the wife.
Absolutely sums it up.
Wow, that was a really thorough deep dive into the intricacies of Islamic marriage law. We journeyed from the very foundation of marriage as a contract, defined by offer and acceptance, emphasizing clear intention, and the critical role of witnesses or publicity.
Through the complex rules around capacity, understanding traditional presumptions of puberty, the differing roles of the wali or guardian across schools, and the historical right of ijbar, importantly noting its significant removal in modern legislation. A reform powerfully illustrated by the Saima Wahid case in Pakistan.
We explored the traditional allowance of child marriage alongside the Hanafi safeguard of the option of puberty, understanding its limitations, and the need for a Qadi's decree, and contrasted this with modern statutory minimum ages and the focus on penalizing adults involved.
We then categorized the various impediments that prevent valid marriage, distinguishing between the permanent bars like relationship by blood, fosters through milk, and affinity, and the temporary ones like being an Ida, limitations on the number of wives, and the specific rules for religious compatibility, particularly for Kitabia women.
And critically, we understood the significant legal distinction between void batil and irregular facid marriages, outlining the specific legal effects of an irregular union like protection from zina, legitimate children, mandatory separation, and specific dower rules, and highlighting that unique instance where good faith regarding an impediment allows ignorance of the law as a defense.
Finally, we dedicated significant time to the essential and unique requirement of dower, mahr, understanding how the amount is determined, stipulated versus proper dower, calculated based on family comparables and personal attributes, how it can be paid, prompt versus deferred, the wife's leverage to refuse consummation for prompt dower, and the crucial specific rules for full entitlement upon consummation or husband's death versus the reduced entitlement, half stipulated or muta al-talaq, if the marriage terminates by divorce before consummation.
And we covered how a marriage is legally proved, from traditional witnesses with adala and indirect evidence to modern registration, and why failure to register doesn't usually invalidate and even contemporary evidence like video.
Exactly. We've covered a lot of ground.
This material, made available by the University of London for educational purposes, really provides a comprehensive overview of the core legal principles governing marriage within Islamic law. It equips you with the key concepts, the conditions, the requirements, and the potential consequences within this system.
And this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
We truly hope that breaking down these sometimes complex rules into manageable sections and exploring them in detail has been helpful, and that you now feel much better equipped to understand this vital area of law. If you are engaging with this material for study or exam preparation, revisiting these key terms, concepts, the distinctions between the schools, the different effects of impediments, and the specific rules for dower, especially the case name Saima Wahid, is absolutely essential for success.
To leave you with a final thought for reflection, consider how these intricate traditional legal principles, developed over centuries based on scriptural sources and juristic reasoning, continue to be interpreted, applied, and sometimes modified or reformed within diverse contemporary legal systems across the Muslim world and interacting with non-Muslim legal systems. How does this ongoing dynamic shape family life and legal realities for Muslim communities today? Something to think about.
Keep revisiting these vital points as you study. They are the building blocks of understanding this area.
Good luck to all of you for the exam.
Thank you for joining us for this deep dive.